Justice and Governance, Griffith University. I'll be your MC for this evening. Firstly, I'd like to acknowledge the traditional owners of the land in which we gather, the Turrbal people and the Jagera people. I would also like to acknowledge the many distinguished guests we have here tonight and with us to honour this occasion. Firstly, the Honourable Tony Fitzgerald, Justice Arthur Chaskalson, the Honourable Cameron Dick, Attorney General, Minister for Industrial Relations, the Honourable Jeff Wilson, MP, Minister for Education and Training, the Honourable Wayne Goss, former Premier of Queensland, the Honourable Justice Margaret McMurdo, AC, President of the Court of Appeal, Her Honour Chief Judge Patsy Wolfe, District Court of Queensland, Mr. Bob Atkinson, Commissioner of Police, Queensland Police Service, Mr. Robert Needham, Chair of the CMC, and Professor Emeritus Roy Webb, AO, former Vice Chancellor of Griffith University. Before proceeding, I'd also like to acknowledge many of the sponsors who've made this night possible. Firstly, the State Library of Queensland, and in particular, I'd like to acknowledge Miss Jane Bertelson, who's the chairperson of the Library Board of Queensland, and also Miss Leah Giles-Peters, the State Librarian. A couple of other key sponsors quickly to mention is the Department of Justice Attorney General's Legal Practitioner Interest on Trust Account Fund, or LIPITAF, as well as the Q150 Community Funding Program. And I'd also like to acknowledge the many sponsors of the Scholarship Initiative, many of whom are here tonight. Other distinguished guests, ladies and gentlemen, it is indeed my pleasure to be emceeing this event this evening. We gather here tonight for the occasion of the inaugural Griffith University Tony Fitzgerald Lecture. This is indeed a special occasion, for it coincides with the month of the 20th anniversary of the handing down of the Fitzgerald Inquiry Report, the Commission of Inquiry into possible illegal activities and associated police misconduct. We also gather here tonight to honour and reflect upon the Fitzgerald Inquiry, its 20th anniversary, its achievements, its legacy, and the contribution of the inquiry to the further development of Queensland as a state. We gather here tonight to consider this period in our own history and also to hear from and learn from one of the leading lights of South Africa, a person who has undertaken tremendously important work in the area of human rights law and who has been instrumental in designing many of the democratic and constitutional reforms in South Africa post-apartheid, Justice Arthur Chaskalson. Tonight's event actually forms a key part of what we are calling the Fitzgerald Initiative, which includes the biannual lecture as well as a dedicated PhD scholarship named in Tony's honour. Why name a lecture and scholarship after Tony Fitzgerald, you might ask? Well, we think the past 20 years have been a significant period in Queensland's development as a state and as a progressive democracy, and we believe it owes much of this to the influence of the Fitzgerald Inquiry. Also, we are mindful of the importance of remembering, of honouring, and of learning from the past, as the lessons of history are usually the most powerful ones. But we are also mindful of the importance of investing and committing toward future research and reform, given that our systems of integrity and governance are necessarily evolving ones. Many of you in this room have experienced living in Queensland firsthand before, during, and after the Fitzgerald Inquiry. While some of you were either directly involved in the inquiry, others were affected in various ways. The larger point is that the Fitzgerald Inquiry represented a key turning point for Queensland. The reforms that have been implemented, the institutional arrangements that have been developed, including the Schools of Criminology and Justice at Griffith and QUT, as well as their associated research centres, owe a great debt to the inquiry and its chairman. And while many people remember the Queensland of the past in the pre-inquiry days, many people do not, as they were not here in Queensland. Indeed, population growth in Queensland over the past 20 years has been substantial. Thus, there is a pressing need to continue to call attention to this period in our history and consider the need for further research and reform. Indeed, the recent events involving political and police corruption, if anything, call attention to the lessons of the Fitzgerald Inquiry, the need for leaders to remain vigilant and provide constant reminders for the current and future generations of professionals who had not experienced the period of the Fitzgerald Inquiry. So through a dedicated PhD scholarship, we can honour the legacy of the Fitzgerald Inquiry as well as provide an investment toward future research into issues that are fundamental to the Fitzgerald Inquiry reforms. In this way, we can contribute toward ensuring that future governance and integrity-related research is maintained and expanded. In this small but tangible way, we can call attention to this legacy, a legacy that has given so much to this state and to this community. I would now like to hand over to Professor Julianne Schultz from Griffith University Centre for Public Culture and Ideas and the founding editor of Griffith Review. She'll provide some further background of the Fitzgerald era. Before handing over to Julianne, though, I just want one small housekeeping matter. If you have to leave during the lecture, please use the back door because these ones are locked. Julianne?
Thank you, Paul. Good evening, ladies and gentlemen. It's a great honour to be here this evening on this important occasion. Several weeks ago, Time magazine published a special double issue. It was called 1989 and explored how the world changed in that year, 2 decades ago. It was a remarkable year when extraordinary, earth-shattering events were happening every day. The magazine drew up a list of what it considered to be the big events of 1989. It was the year the Berlin Wall fell, Russia was transformed by another revolution, America won the Cold War and Francis Fukuyama declared the end of history, the World Wide Web was invented, people dreaming of a fairer political order were slaughtered in Tiananmen Square, F.W. de Klerk agreed to release Nelson Mandela and apartheid entered its death throes, Vietnamese troops withdrew from a devastated Cambodia. The Dalai Lama won the Nobel Prize. A fatwa was declared on Salman Rushdie for the Satanic Verses. Oil from the Exxon Valdez devastated the Alaskan coast. Japan's economic invincibility came to a shuddering halt as a bubble popped. And the first issues of The Simpsons were broadcast. It was a year, Time declared, that history was being made so often in so many places that it seemed almost routine. Time magazine had a predictable emphasis. Some of the things it included were very parochially American, but the sentiment was right. 68 is generally thought to be the year that changed the world, but I'm persuaded that the number you get when you turn 68 upside down and flip it over, that is 89, is more important in terms of lasting global significance in our times. When I picked up a copy of the magazine at Brisbane Airport, I quickly flicked to the table of contents. I knew it was a forlorn and somewhat provincial hope, but I was disappointed to see that the completion of the Fitzgerald Report and the end of the old regime in Queensland did not make the list. It deserved to. It was one of the truly transformative events of Australian history. It not only signalled the end of a particular style of corrupt and authoritarian politics and public administration, but made a wide range of administrative, social and economic changes possible, both here and elsewhere in Australia. We are tardy in this country. We're more inclined to remember, even celebrate, for failure than success. I don't know if it's diffidence, embarrassment or some inversion of egalitarianism, but all too often we fail to recognise the transformations that occur as a result of brave people pushing just that bit harder. There are not many people who, when given a basket full of knotted skeins of wool, keep tugging and pulling, patiently yet determinedly undoing one knot after another, following the thread as it tangles through the mess, until it's all rearranged and packaged in neat bundles. Even fewer provide a plain English instruction manual to ensure that the wool doesn't get messed up again. As Tony Fitzgerald has said to me, becoming such a person was a life-changing event. So it's particularly important to honour Tony and those who with him accepted the unenviable challenge to unravel the complicated and interrelated mess that Queensland was 2 decades ago. It was a mess that had made this state the laughingstock of the nation. It had undermined many of its most talented citizens and sent them scurrying away. It rewarded ignorance and allowed corruption to flourish, all the while encouraging people to believe that they were living in a lotus land where the weather was perfect, when not so far beneath the surface there was a stinking, muddy quagmire. At the time, we knew that the dogged work of the inquiry was important, but it was impossible to judge just how transformative it would become when backed with the political will of the government of Wayne Goss. It's my strong belief if it had not been for this combination of diagnosis and prescription, Queensland would not have become the economic powerhouse it has been for much of the past decade. Economic growth is not sustainable in a corrupt environment. More tangibly, without the experience that came as a result of being close to the government that was elected to implement the Fitzgerald reforms, Kevin Rudd would not be Prime Minister today. Those of us who had grown up in Queensland during the Bjelke-Petersen years were stamped with the often unspoken legacy of a particular time and place, one that out of outrage, fear, exhaustion and eventual transformation taught us about courage and caution in both our personal and political lives, or public lives. When I think back to the Brisbane that I grew up in and the city it has become, it's as though they're two completely different places. I'm thinking about Brisbane before air conditioning, when the river was muddy and the executive building was the highest in the city. Cloudland was a dance venue, the powerhouse still produced electricity, and the smells of food factories and fruit markets, beer brewing, biscuits cooking wafted over the city. Brisbane was hot and sticky, small, clubbish, certain, uneducated, poorer than the other mainland capitals, boozy, brutish and somewhat dissolute. But it was distinctive and in its own way quite charming. In my memory, I can switch back to the emotions, the smells, the texture, the outrage, the despair, the excitement I knew as a young person in Brisbane. When I look around now, there are a few prompts. The hills, the weather, in some suburbs, the houses, the trees, especially the frangipani, jacaranda and poinciana when they're in flower, and the smugness of a certain strata, but not much else. Brisbane today is almost unrecognisable from what it once was. It's a city that's grown up. Paradoxically, it's now a young city, a city with thriving and diverse subcultures, where the internet supplements the mainstream media, and where there are diligent and comparatively well-resourced monitory agencies. Yet, as we have seen in recent weeks, the instruction manual on keeping systems honest and accountable is needed as much now as ever. Generally, I'm impatient with the media-driven celebration of anniversaries that have a zero on the end. But in this case, 20 is a good number. It seems that the angels may have had a hand in the timing, providing us with a tangible reminder of the failings of human nature and the fragility of systems we invent to keep it in check. Places, like people, have genes, memes I think they're called, passed on from one generation to the next. Those here tonight know the embedded history. In one way or another, we lived through it. Now we must work hard to ensure that others who did not do not forget the heritage, both good and bad, from which they have emerged. There is a need for constant vigilance, personal and political courage to ensure that the old ways do not return. But as we saw in 1989, all around the world, and even here in Australia's deep north, transformation is indeed possible. Thank you.
Thanks, Julianne. That was well spoken and well said. Next, I'd like to ask our Vice Chancellor, Professor Ian O'Connor, up to the podium. Thanks, Ian.
Thank you very much, Paul. The Honourable Tony Fitzgerald, ACQC, the very many distinguished guests that are here this evening. I too would like to acknowledge the traditional custodians of the land upon which we gather tonight. And I have the extraordinary privilege tonight and great pleasure of introducing the Honourable Tony Fitzgerald, ACQC. As many of you know, Tony achieved a distinguished legal career at the bar and as a member of the judiciary before being invited to chair the Commission of Inquiry into Possible Legal Activities and Associated Police Misconduct, forever after known as the Fitzgerald Inquiry, in 1987. While a member of the bar, he established a reputation as one of the state's most capable commercial counsel. He took silk at the extraordinarily young age of 34 and was regarded throughout the profession as an advocate of awesome ability. He was the youngest appointee to the Federal Court of Australia in 1981. He was just 38 and was the Federal Court's first resident judge in Brisbane. He gained a reputation for the acuity and precision of his legal decisions. He was held in such high regard that he frequently sat on the full federal court and other state capitals, where he was allocated the most difficult and challenging cases. He returned to the bar in 1984 and concentrated exclusively on appellate work until he was appointed to conduct the Fitzgerald Inquiry. Over the 2 years of its operation, the Fitzgerald Inquiry made a dramatic impact on public life in Queensland and influenced, as Paul and Julianne have both said, the entire institutional framework of the state, as well as becoming a model for other inquiries. While the initial terms of reference were narrow, Tony twice had those terms of reference expanded to allow him to inquire into any other matter, whether they were directly related or not. He set a precedent for royal commissions in Australia, using methods such as indemnities from prosecutions for key witnesses in return for giving evidence. The Fitzgerald Inquiry or report contained more than 100 recommendations which led to significant changes to our policing system, our system of governance and our political system, and provided a blueprint for governments in other Australian states and indeed internationally. They covered both the establishment of the Electoral and Administrative Reform Commission and the Criminal Justice Commission, and reform of the then Queensland Police Force. It led to a significant number of prosecutions and convictions. Importantly for the university, the inquiry also served as a catalyst and inspiration to many researchers and practitioners in the field. In particular, it had a major impact on Griffith University, which at that stage in 1987 to 89 was a relatively new institution, having taken its first students in 1975. The Fitzgerald Report and the reforms it instigated played a key and direct role in the university attracting two of our most respected academics, Professor Ross Hommel, Professor Charles Sanford, as foundation professors in justice administration and law respectively. Professor Hommel and Sanford established their own research centres, and in 1999, together with public policy professor Pat Weller, they became the leaders of the Australian Research Council's key centre in ethics, law, justice and governance, which the Honourable Tony Fitzgerald was the chair of the first advisory board. He also served as the inaugural chair of the Griffith University Innocence Project Advisory Board, a most appropriate role for a person who through his work has created a much safer criminal justice system. Griffith recognised the great contributions and strengthened its relationship with Tony Fitzgerald when it made him a Doctor of the University in 2003. He received a Companion of the Order of Australia in 1991 and has appropriately been recognised with honorary doctorates from the Queensland University of Technology and the Sunshine Coast University. Now, although the original Fitzgerald Inquiry was undoubtedly a hard act to follow, he has made a major contribution to our state and to public life since that period of time, among his many roles including leading a commission of inquiry into the conservation, management and use of Fraser Island and the Great Sandy region, which saw an end to logging, and Fraser Island subsequently being listed on the World Heritage Register. He chaired the Australian Heritage Commission. He was the inaugural president for the Queensland Court of Appeal from 1991 to 1998. And he chaired the Cape York Justice Study in 2001, an investigation into alcoholism and child abuse in the Cape York's Indigenous communities. On the 20th anniversary of the release of the Fitzgerald Report, our focus is not just on dwelling on the events of the past, but importantly, looking forward to ensuring that the legacy that it produced is continued through a new generation of students and practitioners with the passion, commitment and tenacity to continue the evolution of our system of parliamentary democracy. The Honourable Tony Fitzgerald, ACQC, is a person to whom Griffith University, the state of Queensland and the Australian nation owes a great debt, and he's surely become one of our state's and nation's defining figures. I'm most grateful, and the university is most grateful, that Tony has lent his name to this very important annual lecture. So please join me in making welcome the Honourable Tony Fitzgerald.
Thank you very much. Family, the Honourable Arthur and Dr. Lorraine Chaskalson, Vice-Chancellor, friends and other distinguished guests. It's a wonderful privilege to welcome Arthur and Lorraine to Queensland. Their attendance tonight is a great honour. However, before I briefly elaborate on Arthur's achievements, I have two self-appointed tasks. The first is to express my deep gratitude to family and the true friends who've stayed the distance and remain loyal throughout what has sometimes been a difficult and often an unpopular journey. To the Chancellor, Vice-Chancellor and Council of Griffith University for this and other honours, the steering committee members who've generously given their time and energy to organising these events, and the wonderful Griffith staff, Professor Paul Mazarole, Jenny Wilson, Deborah Marshall, Rachel Williams and others, who've worked so hard to make the event successful. And to Gary Crook QC, who was Senior Counsel when I conducted the corruption inquiry from 1987 to 1989, and the outstanding team of lawyers, police, accountants, public servants and others, in the end totalling somewhere between 180 and 200, if I remember correctly, whom Gary led so ably. Because of possible repercussions for Gary, I've been reluctant in the past to speak of his role and the role his colleagues played in my corruption inquiry. But now he's left legal practice and public life and is hopefully beyond retribution. During his career, Gary made an exceptional, indeed unique, contribution to Australia. After acting as Senior Counsel assisting my Queensland inquiry, he was Senior Counsel assisting Justice Jim Wood's inquiry into New South Wales police corruption and later Chairman of the National Crime Authority. In each of those roles he exhibited great legal skill and judgment and accepted huge responsibility and significant personal risk. He has never been publicly acknowledged for his work. In about 1999 or 2000, I nominated Gary for an award in the Order of Australia. Jim Wood seconded the nomination. Two other New South Wales Supreme Court judges who had appeared as Gary's juniors when he assisted Jim Wood were referees. Gary was overlooked. Of course, there might not have been mean-spirited political interference. It's theoretically possible that there was an exceptionally strong field that year. Gary and I knew at the time of the inquiry that our cards were permanently marked, but neither he nor his team ever wavered in the pursuit of truth in the public interest. I salute them, one and all. My second task before introducing Arthur is to seek your support for the PhD scholarship which Griffith is providing as part of this initiative. I propose to speak bluntly. Every generation has a duty to historical truth. At the end of 1989, in the aftermath of my inquiry, Queenslanders decided that they had had enough of the systemic corruption and repression of Bjelke-Petersen and some of his cronies and voted in a new government. Wayne Goss, Matt Foley and others were elected in a spirit of renewal and reform. The Electoral and Administrative Review Commission and the Criminal Justice Commission, after a slow start, did some sterling work. Glyn Davis and Peter Coldrake set out to redesign and energise the public sector. There was an attempt to modernise the court system and revitalise a moribund judiciary by the establishment of a Court of Appeal and a Litigation Reform Commission, and subsequently, when Matt Foley became Attorney General, the welcome, long overdue appointment of female judges. However, by the mid-1990s, Australia generally had wearied of change and moved to the right, and Queensland, where a long period of Conservative government had consolidated a predisposition to conservative thought, moved right with the rest of the country. Pardon me. The Pauline Hanson One Nation phenomenon would soon emerge, again in Queensland, and a coalition of nationals and so-called liberals, including relics of the Bjelke-Petersen era, regained power in Queensland with the help of the police union. The Connolly-Ryan inquiry was soon set up to discredit the reforms which had been introduced on my recommendation so that they could be dismantled with minimum community disquiet. But that exercise failed when the Supreme Court stopped the farce because of Connolly's manifest bias. It soon became apparent to Queenslanders that the coalition was at that time still not fit to govern, but it had succeeded in interrupting and damaging the reform process. By the end of the coalition's term in power in 1998, the political situation in Queensland was volatile. Wayne Goss had departed from politics. The Labor Party was led by Peter Beattie, and much of the principled willingness to confront Queensland's dark past had been lost, and with it the momentum for reform. I had always known that I might have to leave Queensland to work elsewhere as a consequence of my inquiry, and in 1998 I accepted that that time had come, resigned and took up a position in New South Wales. Labor regained power in Queensland in 1998 and has retained it ever since. Perhaps on its assessment that's all that matters. Perhaps to it, the adverse consequences of its political tactics are just collateral damage. Under Beattie, Labor decided that there were votes to be obtained from Bjelke-Petersen's remaining adherents in glossing over his repressive and corrupt misconduct. Tacitly, at least, Queenslanders were encouraged to forget the repression and corruption which had occurred and the social upheaval which had been involved in eradicating those injustices. Younger Queenslanders know little of that era and are largely ignorant of the possibility that history might be repeated. Ethics are always tested by incumbency. Secrecy was re-established by sham claims that voluminous documents were cabinet in confidence. Access can now be purchased, patronage is dispensed, mates and supporters are appointed, and retired politicians exploit their connections to obtain success fees for deals between business and government. Neither side of politics is interested in these issues except for short-term political advantage, as each enjoys or plots impatiently for its turn at the privileges and opportunities which accompany power. Unfortunately, cynical, short-sighted political attitudes adopted for the benefit of particular politicians and their parties commonly have adverse consequences for the general community. The current concerns about political and police misconduct are a predictable result of attitudes adopted in Queensland since the mid-1990s. Despite their protestations of high standards of probity, which personally might well be correct, and irrespective of what they intend, political leaders who gloss over corruption risk being perceived by their colleagues and the electorate as regarding it of little importance. Even if that is correct, it is a disastrous perception. Greed, power and opportunity in combination provide an almost irresistible temptation for many, which can only be countered by the near certainty of exposure and severe punishment. The good news is that even if we cannot rely on politicians to voluntarily curb their excesses or tell the truth, a well-informed community which is committed to doing so can influence the way it is governed, just as Queenslanders did in 1989. Matters are much better now than they were, but it is a mistake to take that for granted. Universities which inform and increase community awareness and understanding provide one of our best defences against historical amnesia and revisionism by speaking truth to power and assisting us to confront, acknowledge and learn from the past. Although I no longer have a role to play, a matter of almost universal satisfaction, I'm delighted to be associated with Griffith University's good governance initiatives. I urge you to support those initiatives, especially the proposed scholarships which need funding. The young academics who stand to benefit from that funding will be much needed contributors to future good governance in Queensland. Let me move on to a much more pleasant topic. Arthur Chaskalson is considered by many to have been the greatest South African lawyer and one of the greatest South Africans of his generation. He was born in 1931, attended the University of the Witwatersrand, graduating summa cum laude in 1954, and was admitted to the bar in Johannesburg in 1955. His was from the outset a stellar career which led to his taking silk at a very young age. His commitment to human rights was immediately obvious. He represented members of the liberation movements in major trials between 1960 and 1994, including the Rivonia trial in 1963-64, at which Nelson Mandela and other leaders of the African National Congress were convicted and sentenced to life imprisonment. In 1978, Arthur put aside his flourishing private practice as a barrister in Johannesburg and became the inaugural director of the Legal Resources Centre, where he remained until 1993, by which time the apartheid era was crumbling, under pressure from him and other well-known heroes like Mandela. The Legal Resources Centre is a South African human rights organisation which, under Arthur, used law as an instrument of justice during the evil apartheid era, using law for the vulnerable and marginalised, including poor, homeless and landless people and communities who suffered discrimination by reason of race, class, gender, disability or social, economic and historical circumstances. With Arthur as counsel, the Legal Resources Centre challenged the implementation of apartheid laws. His courage in defying the Afrikaners' belief that they were superior to other races, and Lorraine's courage in supporting him are amazing. When we speak of repression here in Queensland, we think of an era in which there was certainly brutality involving the police as an instrument of the state. When we speak about repression in South Africa, we speak about an unbelievably hostile and violent society in which those perceived to be the enemies of the state were routinely killed. As apartheid ended, Arthur served as a consultant to the African National Congress on constitutional issues and as a member of the Technical Committee on Constitutional Issues, which was appointed in May 1993 to give advice on constitutional matters and to draft the transitional constitution by the multi-party negotiating forum which negotiated the transition to democracy in South Africa. In June 1994, Arthur was appointed by President Nelson Mandela to be the first president of South Africa's new constitutional court, and when a vacancy arose, he became the Chief Justice of South Africa from November 2001 until his retirement in 2005. He was the first chairperson of the Southern African Judges Commission and Association of the Chief Justices of Southern Africa, the President of the International Commission of Jurists, the chairperson of a committee of senior judges appointed by the United Nations Environmental Programme to promote and develop judicial education on environment law in all parts of the world, and recently chaired the eminent jurors panel appointed by the International Commission of Jurists to inquire into the impact of terrorism and counter-terrorism on the rule of law, human rights law, and, where relevant, international humanitarian law. Arthur has received many awards for his work in promoting human rights, is the recipient of numerous honorary doctorates, and has been awarded a national honour for his service to the nation in respect of constitutionalism, human rights and democracy. On his retirement, he was described by President Mbeki as a giant among the architects of our democracy. It is an enormous privilege to consider Arthur and Lorraine as personal friends, and they honour us by their participation in these Griffith initiatives. Please join me in welcoming Arthur and inviting him to address us.
Well, thank you very much indeed for that warm and very generous welcome. It is a great pleasure for Lorraine and me to be with you on this occasion, and I'd like to thank Griffith University for inviting us to be with you tonight, and in particular to thank Paul Mazerow for assisting us and helping us in many different ways, both before and since our arrival in Brisbane. It's an honour to deliver the first Tony Fitzgerald Lecture, and to do so here in Queensland in the presence of Tony Fitzgerald and his wife Kate Fitzgerald. Griffith must be congratulated for instituting this lecture and the scholarships attached to it. The biannual lecture will remind Queenslanders of the corruption and lawlessness to which others have referred already, which was once at the heart of their police force, and of the closed and secretive political order that made this possible. That is important, for we so easily forget our past and fail to heed its lessons. And the scholarships are also important. Not only will they offer opportunities for aspirant law students, but because they are named for Tony Fitzgerald, they will encourage the recipients to follow his example of seeking the truth, and to have the courage and determination to follow the truth wherever it may take them. What led Tony Fitzgerald along this path 20 years ago was an order in council published in the Queensland Government Gazette on the 26th of May 1987, appointing him to make full and careful inquiry into the correctness of certain allegations concerning the Queensland Police that had been aired in the media. There had been previous allegations of corruption against the Queensland Police, which had come to nothing. And at that time, as the Commission report records, many thought that the pattern would be repeated and that the investigation would prove to be ineffectual. But this is not what happened. Tony Fitzgerald took seriously the instruction to him to conduct a full and careful inquiry. Before accepting the appointment, he obtained assurance from the acting Premier that he would be able to conduct an honest and comprehensive inquiry. And the Commission's report records that soon after his appointment, steps were taken to consolidate this commitment made by the acting Premier and to establish the public credibility of the Commission. Reference has already been made to the increasing of the terms of reference, the broadening of the terms of reference of the Commission at the instance of Tony Fitzgerald. And the report also records the fact that he asked for access to all police and government documents. This was no formality. The inquiry report records that the Justice Department and the Police Department tried to prevent this, raising issues of privilege, confidentiality and sensitivity, and warning of the dire consequences of providing unvetted police department and other government material to the Commission. There were indeed consequences. I wonder whether they thought of them at that time. But with the support of the acting Premier, the Commission was able to obtain all the records without exception. Even cabinet minutes and associate documentation were made available. And this set the stage for a wide-ranging inquiry into corruption. The bare statistics show the depth of the inquiry that was undertaken. 238 sitting days, 339 witnesses, 21,504 pages of transcript, and 2,304 exhibits. The result has been described by other speakers this evening. But what needs to be acknowledged tonight, as we recall the events of that time, is the courage of Tony Fitzgerald, the enormous personal stress to which he, his team and their families were subjected over the 2 years of intense work involved in confronting a corrupt police force and politicians who supported them, and in exposing the deceit and dishonesty that existed. It is also important, I think, to acknowledge the role of the media in exposing the corrupt conduct that led to the inquiry, in being willing to confront the hazard of lawsuits likely to follow the expose, and the personal and financial risks involved in the investigation and the publication of the information that led to the appointment of the Commission. What lessons can we learn from these events? We know from bitter experience that power can be abused. I've seen that in my own country, which is subjected to more than 3 centuries of colonialism, white supremacy and apartheid. Colonialism and post-colonial South African constitutions prior to 1994 excluded blacks from any effective say in the government of the country. Apartheid laws denied blacks, who were the overwhelming majority of South Africans, access to proper education, to work opportunities other than in menial occupations, the ownership and occupation of most of the land, and to fundamental rights and freedoms essential to self-esteem and self-development. And this led to vast social and economic disparities between we who were white and privileged by apartheid and those who were oppressed by it. It caused poverty, degradation and suffering on a massive scale within the black community. The type of society that we have depends to a large extent on the laws of our country. I say to a large extent because even good laws are not in themselves sufficient to prevent the abuse of power. That depends in addition on institutions of government and their integrity, on political will, resources, development, and a host of other factors, social, economic, educational, and cultural. But law and government have a central role, either actively in promoting and working to legitimize particular ends, or passively by failing to prevent abuses. Addressing the issue of good government, the Fitzgerald Report states that this is more likely to result if opposition, criticism, and rational debate are allowed to take place. Appropriate checks and balances are placed on the use of power, and the administration is open to new ideas, opposing points of view and public scrutiny. But what checks and balances are appropriate to achieve these ends? In common law countries, a constitutional principle designed to prevent the abuse of public power is the rule of law. But what do we mean when we talk about the rule of law? In a lecture on that topic, Lord Bingham, then the senior judge of the House of Lords in the United Kingdom, described the core of the rule of law as being that all persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly and prospectively promulgated and publicly administered in the courts. But is that enough? And is it all that is embraced by this principle? For some, the answer would be yes. For instance, one highly respected scholar once observed that a non-democratic legal system based on the denial of human rights, on extensive poverty, on racial segregation, sexual inequalities, and racial persecution may in principle conform to the requirements of the rule of law better than any of the legal systems of the more enlightened Western democracies. It will be an immeasurably worse legal system, but it will excel in one respect, in conformity to the rule of law. For Lord Bingham, there is more to the rule of law than the bald description of its core. There must, he says, also be a substantive content to the law itself, requiring legal protection of such human rights as within that society are seen as fundamental. Otherwise, and I quote again, a state which savagely repressed or persecuted sections of its people, could not be regarded as observing the rule of law, even if the transport of the persecuted minority to the concentration camp or the compulsory exposure of female children on the mountainside were the subject of detailed laws, duly enacted and scrupulously observed. Now, this may sound over the top to tonight's audience, but it has a resonance for people like me who lived through apartheid, and possibly for the Australian families of the stolen generations. Even before apartheid was institutionalized, South African law was corrupted by racial discrimination. The attitude of the courts to discriminatory legislation and the denial of fundamental rights appears from a 1934 judgment of the Appellate Division, then our highest court, where it was said that Parliament may make any encroachment it chooses upon the life, liberty, or property of any individual subject to its sway, and it is the function of the courts of law to enforce its will. Paying lip service to the rule of law, courts followed the laws and held government officials to account when they failed to comply with them. Apartheid laws upheld by the judiciary were clear, publicized and stable. The apartheid government, its officers and agents were accountable in accordance with the laws, but the laws were unjust. They failed to protect fundamental rights such as freedom of assembly and freedom of speech. Instead, they denied the franchise to blacks, institutionalized discrimination, denied equal education and job opportunities to black persons, made provision for forced removal of black communities from land which they owned and occupied, sharply curtailed freedom of political activity, and vested broad discretionary powers to the executive to enforce these policies. I have spoken elsewhere on the role of the courts under apartheid. Their role was complex, and it is not simply the role of ratifying and giving effect to an unjust system, but in effect, in the long run, that is what they did. And what kept apartheid in place in these circumstances was an ideology rooted in the history of colonialism and white supremacy, the self-interest of the dominant white community, a government determined to have its way irrespective of the suffering caused by its policies, draconian security laws, and a constitutional order based on the supremacy of Parliament. In this setting, the law served to reinforce the belief of whites in their racial superiority, and to that extent legitimated it within the white community. In a different context, we can see similar phenomena by looking at the laws of most southern states in the United States of America prior to the changes wrought by the civil rights movement through the courts in the second half of the last century. The laws sanctioned policies of segregation and discrimination and legitimated them in the states where they were practiced. And it was laws that sanctioned the mistreatment here of the stolen generations of Aboriginals. Without a substantive content, there would be no answer to the criticism sometimes voiced that the rule of law is an empty vessel into which any law could be poured. However, most democracies now accept that there are certain fundamental rights and freedoms to which all people are entitled. This is consistent with the international legal order established by the United Nations in the aftermath of the Second World War. The Charter of the United Nations reaffirms faith in the fundamental rights, in the dignity and worth of the human person, and in equal rights of men and women. And member states pledge themselves in the Charter to promote universal respect for and observance of human rights and fundamental freedoms for all, without distinction as to race, sex, language, or religion. The Universal Declaration of Human Rights, adopted without dissent by the United Nations in 1949, records the pledge made by the Charter to promote universal respect for the observance of human rights and fundamental freedoms, and goes on to proclaim the detailed rights set out in the Universal Declaration as a common standard for all people in all nations. The International Covenant on Civil and Political Rights and the International Covenant on Social, Economic and Cultural Rights were adopted as treaties to give effect to these commitments, and other treaties such as the Convention on the Elimination of All Forms of Discrimination against Women and the International Convention on the Elimination of All Forms of Racial Discrimination, and many more adopted during the second half of the last century, fleshed out the commitments made in the Universal Declaration. At the beginning of the present century, heads of state meeting at the United Nations in New York adopted the Millennium Declaration as a resolution of the United Nations in which they resolved to respect fully and uphold the Universal Declaration of Human Rights and to spare no efforts to strengthen the rule of law, as well as respect for all internationally recognized human rights and fundamental freedoms, and to strengthen the capacity of all their countries to implement the principles and practices of democracy and respect for human rights. Now, if this commitment to human rights and fundamental freedoms is an essential component of a democratic society, how should it be expressed in the country's legal system? We had to confront this issue when apartheid collapsed and a new democratic legal order was established in South Africa. We had seen how the doctrine of the supremacy of Parliament had operated to immunize apartheid laws and practices from judicial review. We wanted to ensure that the commitment to a new political order, based on respect for fundamental rights and founding values of our Constitution, would be respected in substance as well as in form. And to this end, we entrenched fundamental rights and the rule of law and judicial review in our Constitution. I've lived through apartheid and have seen what can happen when there are no constraints upon the exercise of power. And if we look back on the world during the last century, we see examples of this in every continent, by people of all ethnicities, of all religions and of no religion. Nazism in Germany and Austria, fascism in Spain and Portugal, segregation and racial discrimination in the United States of America, and more recently, rendition, torture, in Guantanamo Bay, in the island thought to have no law, the military dictatorships in South America, the communist regimes in Eastern Europe and Russia, the Cultural Revolution in China, autocratic regimes in the Middle East and Myanmar, the colonial occupancies of Africa and Asia, post-colonial regimes in these continents, the conflict-driven societies in Israel, Pakistan, and Sri Lanka, and the treatment of Aboriginal communities here in Australia. The list is endless. These examples concern the exercise of state power. But the abuse of power in the private sphere can also have devastating consequences. Illustrations of this would include the history of discrimination against women in almost all parts of the world, racial discrimination in countries where the majority of the people are white, and discrimination in Europe and elsewhere against marginalized groups such as the Roma. Here too, the list is endless. In almost all countries, there are marginalized people who are seen by those who wield power as being not like us. How then, how should the law of a democratic country guard against the abuse of power and corruption, hold a government accountable for its actions or lack of actions, protect those who are vulnerable, and ensure that everyone's fundamental rights are respected and upheld? For a long time, common law courts depended on the doctrine of legality, an incident of the rule of law, to hold government to account. Public authorities were obliged to perform their functions in accordance with the law and could be held to account by the courts if they failed to do so. Holding public authorities to account through the courts was, however, constrained by various factors. By the content of the laws they were obliged to enforce, by the absence of any requirement the reasons be given by the public authorities for their decisions, by the inability of the public to gain access to information in the possession of the government, by strict rules of standing, and by the deference shown by courts to the executive. This is alluded to in the Fitzgerald Report, which called for statutory provision to be made for access to information, for existing complicated judicial remedies to be simplified, for the broadening of the rights of individuals to bring applications for administrative review, for interested parties to be given the right to obtain reasons for the decisions affecting them, and for the system of review of the merits of the decisions by an independent review body. In the 20 years since then, many of these recommendations have been implemented, though only recently it seems, have steps been taken to introduce a comprehensive civil and administrative tribunal for Queensland. These measures have broadened the ways in which the executive can be held to account, but they are directed to the executive and not to the legislature. In Australia, certain implied freedoms are apparently protected by limiting the power of the legislatures to curtail them. Though important, these implied freedoms have to be harmonised with the supremacy of Parliament and have a comparatively narrow application. Federalism disperses power, and to that extent provides a check and balance against the concentration of power in one centre. But it does not address the issue of legislative supremacy, which treats the political process as their only means of control over federal and state legislatures within their fields of competence. In South Africa, we took a different path when we entrenched fundamental rights in our constitution. In doing so, we followed the same path as other countries have done when they emerged from the yoke of repressive regimes. This happened in Germany after the defeat of the Nazis in the Second World War, in Spain and Portugal after the end of fascism, in countries in the southern cone of South America after the eclipse of the military dictatorships, in Eastern Europe and Russia after the collapse of communism, in India and other countries in South Asia after colonial rule. Influenced by the UN Charter and the Universal Declaration of Human Rights, fundamental rights have also been entrenched in other countries, such as Canada, and in the many states of the Council of Europe, whose recent histories have not been so stark. In a constitutional democracy, the effect of the doctrine of legality is that the legislature, and not only the executive, may exercise no power and perform no function beyond that conferred upon them by law. Our Constitution makes this clear, stipulating that the Constitution is the supreme law, and that law or conduct inconsistent with its provisions is invalid and of no force and effect. A Bill of Rights binds all organs of state, including Parliament. The judicial authority is vested in independent courts, which are required by the Constitution to declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency. Should legislatures be constrained in this way? There has been debate and disagreement, particularly in the United States of America, but not only there, about the legitimacy of judicial review of legislation. And that, I understand, is also an issue here in Australia. Strong arguments can be marshalled for the competing views. Each country has its own culture and its own history, and what is appropriate in one is not necessarily appropriate for another. Let me talk first about South Africa. Our Constitutional Court has said, our history is one of repression, not freedom, oligarchy, not democracy, apartheid and prejudice, not equality, clandestine, not open government. You may think that in such circumstances, it is not surprising that we chose constitutionalism over the supremacy of Parliament. Some might argue that this is not consistent with democracy. But that begs the question. Democracy is government by the people. If the people vest the power to govern in elected representatives, they are entitled to prescribe how that power should be exercised. If they say that power must be exercised in a certain way and within prescribed limits, for instance, within the framework prescribed by a Bill of Rights or within a federal structure, democracy and legality require that those procedures and limits must be observed. Constitutionalism is not inconsistent with democracy. It is a form of democracy, and one adopted today by most developed democratic countries throughout the world. It is sometimes argued that what is inconsistent with democracy is not so much a commitment by the legislature to uphold and respect fundamental rights enshrined in a Bill of Rights, as the vesting in the judiciary of the authority to determine whether the legislature has complied with that commitment. But if not the judiciary, then who should make this decision? Some would say the legislatures themselves or the people at the next election. Leaving such matters to the legislatures, however, is saying in effect that there is no control other than through the electoral process over how legislatures exercise their power. But as Justice Jackson said in the decision of the United States Supreme Court in West Virginia State Board of Education against Barnett, the very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. One's right to life, liberty and property, to free speech, a free press, freedom of worship and assembly, and other fundamental rights may not be submitted to the vote. They depend on the outcome of no elections. There are, of course, arguments that go the other way. Landmark cases dealing with issues of great importance in society may ultimately be decided by a majority of a divided apex court, showing that people of good faith could reasonably hold different views on whether or not the legislature had exceeded its power. If that be the case, some ask why the views of a majority of unelected judges should prevail over a majority of the elected representatives of the people. And the answer is that there must be a way of determining disputes as to legality. And in a democracy, this is the role of the legislature. This is not the role of the legislature, it is the role of the judiciary. Judges are not self-appointed. They are appointed and derive their power from the same source as Parliament, from the Constitution itself. Constitutions constrain the power of the legislature in various ways, both procedural and substantive. For instance, most constitutions prescribe special procedures and special majorities for amendment to the Constitution. Federal constitutions assign certain powers to the federal government and others to state governments. Disputes in regard to such matters are not determined by a parliamentary majority. They are determined by judges. The constitutional principle of separation of powers requires this to be done. Disputes concerning the powers of various legislatures in a federal state may be complex and raise issues of great importance about which people of good faith could reasonably hold different views. Yet they are determined by unelected judges, and far-reaching decisions may depend on the majority of a divided apex court. And that, too, is a consequence of a separation of powers and the role of a judiciary in a democracy. The argument that the Bill of Rights or that a Bill of Rights or issues arising out of a Bill of Rights should not be decided by unelected judges also fails to give sufficient weight to the contrast between court proceedings and the way modern legislatures function in most countries. Issues that come before the courts are dealt with in the atmosphere of the courtroom, where competing arguments are debated. Courts give reasons for their judgments, and the appeal process allows for those reasons to be examined and ultimately decided by judges of the apex court, who, because of their experience and training, are able to decide issues with due regard to the relevant legal principles and the evidence placed before them. Modern bills of rights unlike the United States model, which has been the focus of much of the debate, have limitation clauses which are of general application and allow a margin of appreciation to the views of the legislature. For instance, the Canadian Charter provides that the rights are subject to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Similar provisions are contained in the South African Bill of Rights and in the New Zealand Bill of Rights. The South African Constitutional Court has explained the practical implications of this. Section 36 is the relevant section of our Constitution, and it requires that where an entrenched right is limited, and I quote now from the judgment of the Constitutional Court, that limitation may be constitutional permissible if it is reasonable and justifiable in an open and democratic society based upon human dignity, equality, and freedom. This provision requires the state or any person asserting that a limitation of a right falls within the provisions of Section 36 to show that the limitation is reasonable and justifiable. It is one of the objects of the Bill of Rights to require those limiting rights to account for the limitations. The process of justifying limitations, therefore, serves the value of accountability in a direct way by requiring those who defend limitations to explain why they are defensible. The South African Constitution empowers courts deciding constitutional matters to make any order that is just and equitable, including the power to limit the retrospective effect of a declaration of invalidity and to suspend a declaration of invalidity for any period and on any conditions to allow the competent authority to correct the defect. Through these powers and techniques such as reading down, reading in, and severance, courts can tailor their judgments to address the particular flaw identified through litigation without striking down the entire law. Contrast this with the role of the legislature as an adjudicator. Legislation is usually enacted on the initiative of the executive, and debates tend to be influenced by the powerful role of the executive in party politics. The debate takes place within the charged atmosphere of a political chamber, which may be influenced by populist rhetoric and pressing political considerations, rather than a commitment to uphold and respect human rights. Deferring accountability until the next election offers little consolation to those adversely affected by discriminatory or otherwise invasive legislation. Elections are seldom determined by single issues, particularly if they affect a minority. Dominant issues are likely to concern matters such as the economy and security, and not how laws impact on people not like us. Some 150 years ago, John Stuart Mill, himself a utilitarian, was constrained to say, the will of the people practically means the will of the most numerous or the most active part of the people. The people, consequently, may desire to oppress a part of their number, and precautions are as much needed against this as in any other abuse of power. In a different context, the Fitzgerald Report made the point that self-regulation is the antithesis of accountability. Minorities shift depending on the issues at stake, and electoral politics, though a check on the way power is used, do not ensure that the right to life, liberty, and property, to free speech, a free press, freedom of worship and assembly, and other fundamental rights will not be infringed by the legislature. This has been emphasized by the South African Constitutional Court, which has said the very reason for establishing the new legal order and for vesting the power of judicial review of all legislation in the courts was to protect the right of minorities and others who cannot protect their rights adequately through the democratic process. Those who are entitled to claim this protection include the social outcasts and marginalised people of our society. It is only if there is a willingness to protect the worst and the weakest amongst us that all of us can be secure that our own rights will be protected. The legislature debates laws in the abstract and not as in court proceedings in the light of the facts of particular cases. If through lack of foresight of the impact the law will possibly prove to have, or the failure to fully appreciate its implications, prejudice is caused to particular sections of the community or to persons engaged in particular occupations, those affected have no remedy. Where a Bill of Rights is supreme, individuals have the opportunity to claim in a domestic court that on the basis of a particular case there is a gap in the law and that their fundamental rights have been infringed. This is an important check on the exercise of public power. Whether Australia should have a Bill of Rights is an issue presently being debated here. The mandate of the committee appointed by the Australian government to inquire into this question is limited by the requirement that any options for change should preserve the sovereignty of Parliament and not include a constitutionally entrenched Bill of Rights. A concern for the sovereignty of Parliament was also an issue in Canada, in the United Kingdom, and New Zealand, where Bills of Rights have become part of the domestic law of these countries. Canada addressed this issue by allowing Parliament or a provincial legislature to enact legislation declaring that an act or provisions thereof shall operate notwithstanding particular provisions of the Charter of Rights. In effect, this allows the legislatures to immunise laws against charter review or override a court decision which it disagrees with. This is permissible in respect to some but not all of the Charter rights, in particular language rights and rights pertaining to the equality of men and women are not subject to an override. And overriding legislation has a limited life of not more than 5 years unless the legislature reenacts the override before the expiry of the prescribed period. An override power can be used to undermine a Bill of Rights. This was in fact done in Quebec, where for a period of 3 years between 1982 and 1985, a notwithstanding clause was inserted into every piece of legislation and into all Quebec legislation existing when the Charter came into force. In effect, this immunized Quebec legislation against Charter review. This, one may think, is not likely to happen if there is a genuine commitment to uphold and respect fundamental rights. And that later proved to be the case in Quebec. The overrides lapsed, and since then the override has been used only on isolated occasions. In the United Kingdom, the Human Rights Act has a different way of dealing with this issue. The Act, in effect, incorporates the European Convention of Human Rights into the domestic law of the United Kingdom. Public authorities must comply with the Convention, and courts are required, where possible, to interpret legislation so as to be consistent with the Convention. If that is not possible, courts may declare the legislation to be incompatible with the Convention. In that event, a Minister of the Crown has a discretion to amend the legislation subject to the approval of a resolution of Parliament to remove the incompatibility. And until now, that is what has happened in every case in which there has been such a declaration. The somewhat complex provisions of this Act are designed to accommodate the United Kingdom's treaty obligations to honour the Convention, allowing its own courts, and not only the courts at Strasbourg, to rule on such issues, whilst in substance preserving the principle of parliamentary sovereignty. In New Zealand, the Bill of Rights applies to all legislative and executive acts and to the exercise of all public power. Although the legislature is required to comply with the Bill of Rights, courts cannot decline to enforce legislation because of an inconsistency with the Bill of Rights. Where possible, however, courts must interpret legislation so as to be consistent with the Bill of Rights. The Human Rights Act in the United Kingdom and the New Zealand Bill of Rights are ordinary statutes and theoretically are subject to revision or repeal by ordinary statutes again. They have, however, had a deep impact on the making of laws, on executive action and the exercise of public power, and on the jurisprudence of courts in those countries. If Australia were to adopt a Bill of Rights, this would give effect to its international obligations under the UN Charter and human rights treaties to which it is party, such as the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the Conventions on the Elimination of All Forms of Racial Discrimination, the Convention on the Elimination of All Forms of Discrimination against Women, the Convention on the Rights of the Child, the Convention against Torture, and the Convention on the Rights of Persons with Disabilities. It would also give substance to the pledge made by Australia and other countries in the Millennium Declaration to spare no effort to strengthen the rule of law, as well as respect for all internationally recognized human rights and fundamental freedoms, by ensuring that these rights and obligations are enforceable not only through international structures, as is the case now, but in and by its own courts. Of course, these obligations can be met by ensuring that Australian domestic law complies with these standards. But a Bill of Rights goes beyond this. It is a declaration to all in the country of the values with which the law must comply. It is a commitment by the government and parliament to uphold those values and to ensure that the fundamental rights of everyone will be respected and upheld. It impacts on the legal culture of the country, influencing not only the way courts interpret and develop the law, but also parliamentary debate, and focuses the attention of drafters of legislation on the importance of ensuring that the law complies with the provisions of the Bill of Rights. The protection of the rights of people within society depends ultimately not upon the provisions of a Bill of Rights, but upon community attitudes and political will. A government determined to exercise power without any concern for human rights and the rule of law is unlikely to be deterred by a Bill of Rights and judges who say that they are acting unlawfully. It is more likely to tear up the Bill of Rights or get rid of the troublesome judges and find others more compliant to take their place. But in a functioning democracy, where there is respect for the rule of law, the symbolic importance of a Bill of Rights, and a legal order in which independent courts are empowered and required to protect such rights can have a profound influence on the culture of society, reinforce an existing culture of rights, and provide a powerful antidote to the pursuit of policies which could lead to the erosion of such rights. This has been accepted by almost all developed democracies in the world. Because of where I come from, and no doubt because of my own professional life and experience, I have come to believe that a legally enforceable Bill of Rights is one of the checks and balances that enhance democracy and ensures that those who exercise public power are accountable for the way that they do so. I have expressed those views in my comments to you tonight. And tonight, on the 20th anniversary of the Fitzgerald Report, I invite you to ask yourselves, whether this is not indeed an essential check and balance, one that is needed in a democratic legal order to protect and reinforce the rights of everyone and to guard against the possibility of power being abused, as it was in Queensland before Fitzgerald more than 20 years ago. Thank you very much.
Thank you, Arthur. That was tremendous. And there's some very important messages in there for our audience and for Queensland. Obviously, you have raised some very important questions about the role of a Bill of Rights in a democracy, in a constitutional democracy, raises the important issues of the relationship between the individual and the state and the separation of powers. And your words were very powerfully spoken and send very important messages for not only us in Queensland, for in Australia as well. So thank you for that. And thanks for being the inaugural speaker for the scholarship. So what I'd like to do also is pass along my appreciation both to yourself and Lorraine as the inaugural speaker for the Griffith University Tony Fitzgerald Scholarship. And coming all the way from South Africa, we know it's a long journey, and we certainly appreciate you making the trip. But as a small token of our appreciation, we have a gift that I'm sure will fit into the suitcase. But thank you so much, Arthur.
Thank you.
It's very inspirational.
Thank you very much indeed. Yeah. Thank you. I think I should tell you about our suitcase. They're not unaccustomed to public speaking. I have in recent years become unaccustomed to wearing ties. And in the not inconsiderable quantity of luggage that we have with us, I forgot to pack a tie. And I am indebted, amongst many other things, that I owe to Tony Fitzgerald for the use of this adornment. And I shall feel that with the absence of the tie will now make place for this. And I hope we will find home for it.
Thank you, Arthur. I have a few more housekeeping matters to work through before we conclude the evening. First thing, I just want to wrap up a few things. Firstly, about the scholarship. I know it's been alluded to by Arthur and been mentioned by Tony as well. We've developed this scholarship because we think it represents a very tangible investment in the future research for governance and integrity, police corruption, public sector misconduct, and related areas. It both honours the Fitzgerald legacy and provides an opportunity for future research. As many of you know, we kicked off the fundraising campaign last September. We still have some way to go towards ensuring that the scholarship is self-sustaining. However, we're at a very exciting point in its development because we're now in a position to formally call for applications for the PhD scholarship. To remind everyone, although it's in your booklet, the scholarships are for 3 years to provide support for PhD level study in an area of research that reflects the Fitzgerald Inquiry era. Applicants can be from various backgrounds: criminological, sociological, legal, psychological, historical, etc., media, public administration. 3 years of funding, $30,000 tax-free per year, And we're interested in several applications, so please feel free to pass it on to your friends and colleagues. The note that now, as of this moment, we can formally announce that we'll be accepting applications for the Griffith University Tony Fitzgerald PhD Scholarship Program. So it's official. I have great pleasure also in just communicating to you about some accompanying events that was mentioned somewhat earlier. So in addition to the Fitzgerald Lecture and Scholarship Program, there's a very significant suite of accompanying events going on in Brisbane very, very soon. This involves the formal opening of an exhibition that features personal effects and exhibits from the Fitzgerald inquiry period. The exhibition will feature items from Tony Fitzgerald's personal collection, as well as artworks, original court drawings, T-shirts, cartoons, and various other items that have been collected during the Fitzgerald inquiry period. The opening is July the 30th. It runs till August the 9th. It's at the Queensland College of Arts College Gallery, just down the street here in South Bank on Tribune Street. After this particular event, as I said, it runs till August the 9th. Tony will be donating many of his personal effects related to the inquiry to the State Library of Queensland. And I understand that the State Library is very delighted to become the custodian of Tony Fitzgerald's personal collection of material from the inquiry, and that they intend to build upon this donation with other material and information from this era, and it will become housed at the John Oxley Library. So special thanks to Tony Fitzgerald for making that contribution for Queensland. My last bit of housekeeping is just to run through the many thank yous, which I think are highly appropriate in making this night possible. I've already thanked our guest speaker, Justice Chaskalson, for his inspiring words and his visit to Queensland. We're very honoured to have him and Lorraine here. I'd also like to thank, for really making this possible, the various members of our steering committee who donated so much of their time, energy, and ideas over a really lengthy period of time. Our steering committee, and they're listed in the booklet, was really represented an interdisciplinary mix of individuals from different areas of academe, from the media sector, and people working in the areas of governance and integrity. To the committee members who included, firstly, Matt Foley, Greg Chamberlain, Richard Johnstone, Tony Keyes, Ross Hummel, Charles Sanford, Janet Ransley, Margot Lagos, David Solomon, Greg Vickery, Noel Preston, Stephen Stockwell, Jenny Wilson, as well as prior committee members Brendan Butler and Susan Johnson, I say thank you very, very much. Secondly, I'd like... Secondly, I'd like to thank the State Library of Queensland for hosting this event, and they've worked very cooperatively with us to make this a reality. I think the venue is fantastic, so thanks again to the State Library. Thirdly, there's a number of administrative staff from Griffith University who helped make the evening a success, and these included Carmel Connors from KELJAG, Kelly Hinchy from KELJAG, and Deborah Marshall from the Griffith University Media Unit. So thank you to Kelly, Carmel, and Deborah. There's two other people from Griffith I'd like to formally thank by asking them up to the stage right now. That's Jenny Wilson and Rachel Williams. Would you please come up to the stage? Firstly, to Jenny Wilson, she's provided a constant sense of purpose and importance to this initiative. She's been intensely committed to the Fitzgerald inquiry since I first met Jenny. So she's been a real driving force and an inspiration to all of us working on this. So congratulations, Jenny. Thank you. And last to Rachel, she's been responsible, Rachel Williams, for a lot of the administrative work that behind the scenes, making sure that the trains ran on time and everything worked. So thank you so much, Rachel. One more piece of And finally, the final person I'd like to thank for tonight is the man who made it all possible. I'd like to invite Tony Fitzgerald up for a second, if you can. Back to stage, Tony. Tony, for your support of this initiative and all your work that you've put into it, for what you provided for Queenslanders, with your judgment, your passion, your tenacity, your commitment to justice, and importantly, for providing the instruments and the tools for others to follow your lead. And on behalf of Griffith University and the Key Centre, I thank you very, very much.
Don't worry, I'm not going to hold you up. As I said before, I'm extraordinarily grateful for the honour that's been done to me, and of course to Arthur and Lorraine for coming, but also to all of you for coming. Thank you very much. And I must say that it is an encouraging sign for Queensland that so many of you remain interested in ensuring that as we move into the future, and in my case pass our society down to my children and their children, and I assume some of you fall into the same category, that you are still interested in the sort of activities that are essential if Queensland is going to be the place that we want those children and grandchildren to live in. Thank you.
So that concludes our evening, and I just again want to thank you all for coming and attending the inaugural Griffith University Tony Fitzgerald Lecture. Thanks again. We have there's tea and coffee on the patio, so please join us.